Welcome students, welcome to lecture number 32 where we will be continuing with module number 6 under subject Indirect Taxation. So as we know under this particular module, that is import-export procedures under custom, which we have already seen introduction to baggage under lecture number 31, general free allowance lecture number 31. Now we have left with provisional assessment of duty, due dates of payment of duty, penalties under customs, seizure of goods and confiscation of goods. As I already told you all earlier, module 6 is a complete theory module. So in our today's session, we will be covering continuation on general fee allowance, which we had left a little part in our previous lecture. So we will be continuing with that little part on general fee allowance, provisional assessment of duty, due dates of payment of duty, penalties under customs, seizure of goods and confiscation of goods is what I will be covering in today's session. So let us first see the continuation which we had left on general free allowance, and then we will begin with the rest. So in general free allowance, we had already seen certain portion and we were remaining with the remaining part. So we were to continue from here. So let us continue. Where the minimum stay of year we had seen that the duration of stay abroad, that when an Indian citizen is going abroad, the duration of stay we had seen for 3 to 6 months. What is the general free allowance given for 6 to 1 year? If he stays in abroad, what is the general free allowance given? Now next we have to see if his minimum stay is for 1 year during the preceding 2 years. So in the last 2 years, suppose if you take the current year, suppose if you take as 2021, preceding to 2021, his stay in the preceding 2 years should, and like in the preceding 2 years, if his minimum stay is 1 year and he brings along with him into India personal and household articles other than those mentioned in Annexure 1 or Annexure 2, but including articles mentioned in Annexure 3 up to an aggregate value of rupees 2 lakhs. So students, here it is clearly saying that if he's getting any article that is mentioned in Annexure 3, which is having a value up to 2 lakh rupees, that is allowed free. Like no duty is to be paid on that particular articles which is getting, provided his stay in the previous preceding 2 years is staying for minimum period of 1 year abroad. Now, this is applicable only to the Indian passenger should not have availed this concession in the preceding 3 years. So this is applicable provided he is not getting this particular concession in the 3 years. So he's not got this particular availment, this particular allowance in the preceding 3 years. Next we see is, and we have already seen in a previous lecture what all articles are covered in Annexure 1, 2 and 3. Next is if his minimum stay of 2 years or more. So he's staying abroad for a period of 2 years or more than 2 years. And suppose he is returning to India and is getting along with him certain personal and household articles other than those listed in Annexure 1 or 2, but including articles mentioned in Annexure 3 up to an aggregate value of 5 lakh is allowed to get without payment of custom duty. That is why they are covered in the general free allowance. So when I when I say that he is getting suppose articles with him which are mentioned in Annexure 3, he will be allowed to get it without payment of customs duty up to a value of 5 lakh. Suppose the total of all the articles that is getting is coming up to 5 lakh and less, he can get that without payment of customs duty, number one. Number two, for that his minimum stay in abroad should be for minimum period of 2 years. And what is the condition? His minimum stay of 2 years abroad immediately preceding the date of his arrival of transfer or on transfer of residence. That means from on the date of arrival into India, his stay in abroad should be for a minimum period of 2 years. Okay. The shortfall up to 2 months in stay abroad can be condoned by Deputy Assistant Commissioner of Customs if the earlier return is on account of terminal leave or vacation being availed by of the passenger or any other special circumstances for reasons to be recorded in writing. So suppose if his stay in abroad for a period of 2 years, that 2 years completion is falling short of 2 months, and that 2 months can be ignored provided the deputy commissioner of customs is satisfied that the reason for the 2 months shortfall to 2 years is for suppose any special situation, okay, or suppose the terminal leave or vacation being availed by of the passenger has availed the vacation or leave for that period, or any other special circumstances, and this reason why there is a shortfall of 2 years in the stay abroad should be in writing. So the period of 2 months, if it is falling short for the completion of 2 years, still this general free allowance can be availed provided that he gives the reason in writing. Next for the same thing, what should be the condition is total stay in India on short visit during the 2 preceding years should not exceed 6 months. Okay, and passenger has not availed this concession in the preceding 3 years. So these are the three conditions to be fulfilled if he has to get a general free allowance on the articles that are specified uh, in the goods that are specified in annexure 3 up to a period of up to a value of 5 lakh rupees. So we have already seen annexure 1, annexure 2 and annexure 3. So here most frequently what will be asked in your examination is about laptops. So then when an particular value about laptop is given, you have to first see the stay of that Indian passenger abroad, and based on that the general free allowance is given. Like again I repeat, if he stays 3 to 6 months he will get up to 60,000 allowance without payment of customs duty. 6 to 1 year, then he will get up to 1 lakh without payment of customs duty. Then again, if it is a minimum stay of 1 year, then it will be 2 lakh rupees, and minimum stay of 2 years or more, it will be 5 lakh rupees. So depending on the stay abroad, so whenever any problem also is given to you all, you'll have to first see how much is the stay, how what is the stay, what is the period of stay abroad. Okay, based on that the general free allowance will be given for all the articles which the person is carrying with him, okay, which is mentioned in annexure 3. Okay, so we are done with the little part that was remaining on general free allowance. Now let us move ahead to provisional assessment of duty. So let us understand what is this provisional assessment of duty. So what happens here? First thing is you need to know reasons why this provisional assessment of duty is done. See students, you all know that customs duty is a self-assessment duty. Like what happens when the importer is importing goods, he will self-assess what is the custom duty to be paid based on the value of imported goods. Okay, now there are certain reasons why or certain conditions why the importer may opt for provisional assessment of duty. See, self-assessment is usually done, but the importer may opt for provisional assessment of duty. Now, what are the reasons for provisional assessment of duty? Let us understand. Suppose the importer or either the exporter is not able to self-assess the tax. See, we know that the customs duty is to be self-assessed based on the value of imported goods. He has to assess, he has to himself find out what is the custom duty payable on that particular import or export. But suppose an importer or exporter is not able to self-calculate the tax. Okay, what he can do is he can make a request to the custom officer, okay, in writing for assessment. He can make a request that he is not able to self-assess the tax, self-calculate the tax, and this has to be in writing, and he has to request it to the proper officer of customs. Okay, either that can be a reason for provisional assessment of duty. Second thing is where the proper officer himself thinks that the goods that are imported or exported has to undergo certain tests. So this is the second reason why provisional assessment of duty is to be done. The third reason is where either the importer or exporter, he has produced all the necessary documents and full information, okay, but the proper officer is finding something fishy and he wants to make further inquiry. If he wants to make further inquiry about the goods that are imported and exported, he can call up for provisional assessment of duty. And the third and the fourth thing is where necessary documents have not been provided or information has not been furnished, okay, and the proper officer wants to make further inquiry. See students, there are four reasons why the provisional assessment of duty can be made. As I've told you all, number one, suppose the exporter importer himself is not able to calculate the tax. Number two, where the officer is thinking that there whatever goods are imported or exported, some further test needs to be done on those goods. Number three, where all the documents are being provided by the importer or exporter, but the proper officer wants and is thinking that further inquiry is necessary on those goods which are imported or exported. Fourth, the proper officer has not received the full information or documents from the importer or exporter on those goods and he wants to make further inquiry. So these are the four reasons or four conditions for which provisional assessment of duty is supposed to be done. The next part, when the duty leviable on such goods is assessed finally or reassessed by the proper officer in accordance with the provisions of this act in case of goods cleared for home consumption or warehouse. So what happens first? First of all, you know the conditions for which one will opt for provisional assessment of duty. Second, what happens once these conditions are fulfilled? Second is whatever tax is nothing but duty. Whatever duty is to be paid on such goods, if it is finally calculated, okay, or the proper officer is recalculating the tax on that, okay, then either he will calculate the tax or recalculate the tax for the goods that are cleared for home consumption, number one. Number two, if it is cleared for warehouse. So in case if the goods are cleared or cleared for home consumption, whatever amount paid, okay, shall be adjusted against the duty finally assessed or reassessed, and any shortfall, okay, suppose if it is an excess of duty finally assessed reassessed, he will get a refund of it. Or suppose if the importer or exporter of goods have paid the duty which is falling less in the value, that is finally assessed or reassessed, he will be have to pay the additional amount. Similarly, what happens when the goods are cleared for warehouse? Okay, the proper officer, when he finally assesses the duty, the in suppose if it is in excess, suppose if the importer or exporter is paying a duty and the duty as calculated by proper officer is more, then that deficit has to be paid by the importer or exporter. And uh, vice versa, suppose if the value calculated by assessing officer is less and the importer or exporter has paid more duty, then that difference will be refunded to the importer. Right now, when the goods are cleared for warehouse, what happens is the importer is required to execute a bond, as I've already told you in my previous lecture, okay, where he has to pay twice of the amount of excess duty. Okay, because since he's keeping the goods in the warehouse, there has to be a bond that has to be executed by the importer, and the value of the bond should be twice of the amount of the excess duty paid, if any. So see students, in short, what I'm telling you is when provisional assessment of duty is done, first the importer exporter will self-assess the duty, and if is not able, but he has to pay certain amount of duty roughly to be calculated by him. So suppose he pays certain amount of duty. Later he leaves it up to the proper officer to recalculate the duty whether he's paid correct duty or no. Suppose he's paid correct duty as calculated by proper officer, there is no need to pay anything or get a refund of anything. Suppose he's paid more duty than calculated by proper officer, then he'll get refund of that. Suppose he's paid a lesser duty, okay, as calculated by proper officer, he has to pay the deficit amount of duty back to the custom authorities. Third is the importer or exporter shall be liable to pay interest on any amount payable to central government consequent to the final assessment order or reassessment order. See, students, as I told you all that suppose if the importer exporter has roughly calculated the duty and paid, and later the duty, actual duty has been calculated by the proper officer. The proper officer is duty calculated by the proper officer is little higher. Suppose the duty paid by the importer exporter is, suppose example, it is 20,000, and that as calculated by proper officer is 25,000. Actually 25,000 is to be paid, importer exporter is paid only 20,000. That 5,000 deficit has to be paid by the importer to the proper officer along with interest. Okay, so interest will be liable to the deficit amount. Now what will happen is, what is the rate of interest? That rate will be fixed by the central government from the first day of month in which the duty is provisionally assessed till the date of payment. So from till when will be the interest calculated, for what period? From the first day of that month in which duty is provisionally assessed, not self-assessed, provisionally assessed, till the date of payment, the interest is to be paid and the rate will be fixed by the central government. The fourth thing is, if any refundable amount is not refunded under subsection within 3 months from the date of assessment of duty, finally assessed or reassessed of duty, as the case may be, there shall be paid an interest. So see, students, if the importer is paying lesser amount, he has to pay interest along with that excess amount. Suppose if, like in the same example, if I continue, if the provisional duty that is assessed is suppose 20,000, and importer and exporter is paid 25,000. So importer exporter self-assessed, roughly he's paid extra 5,000, correct? So you should get a refund of that 5,000. So that period in which he can get the refund from the proper officer is for a period of 3 months. Within 3 months, he should get the refund. Okay, suppose if he's not got the refund within the 3 months, then interest will be payable by the government to the importer. So if the refundable amount is not refunded within 3 months from the date of assessment, provisional assessment, then interest will be payable on such unrefunded amount, that is in the example 5,000, again at a rate which is fixed by the central government, and the interest will be calculated up to the date of refund of such amount. So this is nothing but provisional assessment of duty. First, you need to fulfill the conditions to go in for provisional assessment of duty. The different reasons we have seen. Then the duty will be assessed when the goods are cleared for home consumption or warehouse. Then you have to compare the duty amount, that is self-assessed, like whatever roughly paid by the importer, and provisionally assessed amount of duty. See whether it is excess, deficit. If it is excess, it will be refunded. It should be refunded within period of 3 months. If not refunded, interest will be applicable. If it is deficit, then the importer needs to be pay the amount, and if he is not paid, he will be liable for a interest. Okay, which will, and the rate of interest will be fixed by the central government. Next, let us understand the due dates for payment of duty. So deferred payment, like where the importer is supposed to pay the customs duty, but he's deferred in paying it. So students, due dates for payment of duty, as we already seen, that what will be the rate of duty applicable? Okay, we have already seen, if the goods are cleared, suppose entered for home consumption, then that date of duty will be applicable is the date on which the bill of entry is presented, or the date of entry of inward vessel, whichever is later. We have also seen that if the goods are cleared for warehouse, then what is the rate of duty that will be applicable? The relevant date is the date of presentation of X bound bill of entry for home consumption. And in all other cases, we have already seen that the relevant date is the date of payment of duty. So now in our earlier class, we have already seen the relevant date for date of duty and tariff valuation, which we have already seen. Today, let us see what is the relevant date is the date of payment of duty. So let us understand in this case, what are the due dates? So suppose for goods corresponding to bill of entry returned from for payment from and duty to be paid by. So suppose if the goods suppose if the bill of entry is filed and goods returned for payment is from first day to 15th day of any month. So suppose from 1st to 15th of any month, if the goods are corresponding to bill of entry, then the duty has to be paid within 16th day of that month. So suppose 1st to 15th day of any month, so 1st to 15th date, if the goods corresponding to the bill of entry are returned for payment, then the duty has to be paid by 16th of that month. So suppose on 14th Feb, suppose if the goods corresponding to bill of entry is returned for payment on 14th Feb, so what will be the due date for payment of customs duty? It will be 16th Feb. Similarly, goods corresponding to bill of entry return for payment from 16 day till the last day of any month other than March. So suppose if the goods corresponding to bill of entry return for payment from, suppose you say, I say 17th of July. Okay, so if the date is falling between 16 to the last day of any month, so 17 July, so what is the due date for payment of duty? It has to be paid by 1st of August. So first day of the following month. So July is followed by August, so first day of August. Similarly, if the goods for but exception March, it should not be a month other than March. Okay. Similarly, for goods corresponding to bill of entry entered for payment from 16 day till the 31st day of March. So in the last part, it is only covering the month of March. So suppose it is paid on, it is to be the goods corresponding to bill of entry is returned for payment. Suppose you can see, suppose on 20th March. So what will be the due date up to which the duty is to be paid? Customs duty will be 31st March. So these are the different due dates for payment of duty, that is deferred payment, where the payment can be made up to these particular due dates. Next, let us see penalties for customs, under customs. So penalties is nothing but a fine, a imposition which is imposed by the custom authorities on the importer or exporter. So there is like a charge. Okay, now let us see for what different offenses, what is the different penalties under customs. So suppose if the nature of offense that the importer is doing is, suppose in the case of goods in respect of which any prohibition is in force under the Custom Act or any other act for time being in force. So suppose if any goods are prohibited to be imported and exported, but they are imported and exported. So actually there is a prohibition on those goods, but they are imported or exported. Then they are prohibited goods, but the goods were forcefully imported or exported by them, though they were prohibited goods, but the nature of offense is such that the importer or exporter are dealing in those prohibited goods, then the penalty is penalty not exceeding the value of goods or rupees 5,000, whichever is greater. So either the value of goods you can see, or you can see rupees 5,000, whichever is greater will be the penalty. Second offense, suppose in case of dutiable goods other than prohibited goods. So suppose if any offense is created by the importer exporter in case of dutiable goods. Dutiable goods are goods on which customs duty is leviable, but any kind of offense is created in that particular kind of goods which are not prohibited goods, then penalty will be penalty not exceeding the duty sought to be evaded on such goods or rupees 5,000, whichever is greater. See, many a times when the importer or exporter imports or export dutiable goods, see, dutiable goods are goods on which duty is to be charged, to be levied, and the importer will escape in paying the duty on that goods, will evade, then and if it comes to the notice of the proper officer, then the penalty will be not exceeding the duty ought to be evaded, whatever duty he was trying to evade, okay, or trying not to pay, that duty on such goods or rupees 5,000, whichever is greater, will be the penalty. Third, in the case of goods in respect of which the value declared is higher than the value thereof. Suppose they are declaring a value of goods, okay, which should be higher than the value that they have declared. Then the penalty will be penalty not exceeding the difference between the declared value and the value thereof, or rupees 5,000, whichever is greater. Suppose they had to declare 2 lakh rupees and they have declared only 1 lakh rupees. So that 1 lakh is the amount that they have not declared, either that 1 lakh or 5,000, whichever is greater. The fourth kind of offense is in the case of goods falling both under 1 and 3 above. So 1 and 3 above. So penalty should not exceeding the value of the goods or the difference between the declared value and the value thereof, or rupees 5,000, whichever is higher. So whichever is higher will be the penalty charged in case it is a goods falling under 1 and 2 above. So suppose if it is they are importing prohibited goods as well as they are declaring a value which is more than the value, which is higher than the value thereof, then the penalty will be the penalty that is a difference between that value or rupees 5,000, whichever is highest. Now second, in case of goods falling both under 2 and 3 above. So 2 and 3 is that is they are trying to evade the tax on the dutiable goods and they're declaring a value which is higher than the value there. They are declaring a value which is declaring a value is higher than the value thereof, then the penalty not exceeding the duty sought to be evaded on such goods or the difference between the declared value and the value thereof, or rupees 5,000, whichever is highest. Next, suppose if the nature of offense is in case of goods in respect of which any prohibition is in force under the Customs Act or any other law for time being in force. So the penalty not exceeding 3 times the value of goods as declared by the exporter or the value as determined under the act, whichever is greater. So your penalty is, see, here we had seen in this particular case was these were the penalties for improper import of goods. These were the penalties. Now in this particular slide, there are penalties for improper export of goods. This particular slide is penalties for export of goods. This slide was for import of goods. So in export of goods, if there is any prohibition which is there, but still the goods have been exported, the penalty not exceeding 3 times of the value of the goods as declared by the exporter or the value determined under the act, whichever is greater will be the penalty. Suppose in case of dutiable goods other than prohibited goods, then penalty not exceeding the duty sought to be evaded on such goods or 5,000, whichever is greater. And in the case of any other goods, the penalty not exceeding the value of the goods as declared by the exporter or the value determined by the Customs Act, whichever is greater. So either the value declared by the exporter or the value that is calculated as per the Custom Act, whichever is greater will be the penalty. So remember, these 3 situations are for penalty for improper export of goods, and these 5 situations were for penalty for improper import of goods. These were the different penalties. Later, there is also penalties in case of goods loaded in a conveyance for importation into India or goods shipped under the provisions of the Customs Act 1962. So the penalty not exceeding twice the amount of duty that would have been chargeable on the goods not unloaded or the deficient goods, as the case may be, had such goods being imported. So it is like penalty for uh, on the person in charge of the conveyance, okay, who's in charge of the conveyance. So in respect of the goods to be loaded in a conveyance for importation in India or goods shipped, okay, so the penalty will be not exceeding twice of the amount of duty which would have been chargeable on the goods not unloaded or the deficient goods. Now in case of coastal goods, in the case of coastal goods, the penalty not exceeding twice the amount of export duty that would have been chargeable on the goods not unloaded or the deficit goods, as the case may be, had such goods been exported. So this first thing is for the imported goods. This second part is for the exported goods. Next. Next is seizure of goods. Now it's very important to understand what is the meaning of seizure. Now students, before we see the provisions of seizure, let us understand what does seizure of goods mean. So seizure simply means taking the possession of assets, okay, which have not been disclosed to the custom authorities. So simply seizure just simply means that taking possession of assets which has not been disclosed, actually disclosed. Okay, so let us see. Confiscation means lawfully seize of illegal import of prohibited goods. Okay, so taking possession of assets which is not coming to the notice of the custom authorities is nothing but illegal import. Legally importing means you will declare everything what you're importing in the declaration form or in the bill of entry, right? But illegal import means something that you're hiding, taking a possession of some assets without bringing it to the notice of the custom authorities. So that is illegal import. Okay, so confiscation, now this word you need to understand. Confiscation means taking away as a punishment. So when seizure of goods happens, so suppose if I'm an importer and I'm illegally bringing some goods into India, so this becomes a seize of illegal import. Now, to give me a punishment, okay, as since I'm an importer and I have taken an illegal import, who will punish me? The custom authorities by confiscating. Now, confiscation means taking away those possession of assets by the custom authorities as a punishment to the importer because he has lawfully because he has illegally imported prohibited goods. So let us now understand. Confiscation means lawfully seizing. So confiscation, when suppose if the custom authorities are confiscating the goods, that means they are lawfully doing it. They are giving you the punishment for seizing of illegal import. So confiscation means lawfully seize of illegal import or prohibited goods into India and seize of conveyance in Indian customs water for concealing of exported goods or carrying smuggling of any goods. So what happens when suppose the importer or exporter is smuggling the goods? Then the custom authorities have full right to seize such goods, okay, and they also have the right to take away the conveyance on which such goods were being imported or exported. So confiscation of goods or conveyance are two ways by which a custom authorities can exercise his statutory power as provided under Customs Act 1962. So suppose if the importer or exporter is hiding something or is illegally doing some import export, what is the power that the custom authority has? Either he can punish by taking those goods from the importer or exporter, or that is he can confiscate, that is taking it away, take away those goods, or he can take away that conveyance. So these are the two rights which the custom authority has in respect of the goods that are illegally being imported. The action of seizure precedes confiscation. So before confiscating happens, there has to be seizure. So seizure is the first process, then there is confiscation. So confiscation will happen only when seizure is there. So seizure precedes confiscation. And any goods cannot be confiscated directly without exercising action of seizure. So seizure, as I already told you all, seizure is nothing but it is taking away the goods. Simply means that taking possession of assets which has not been disclosed. Okay, so suppose if an particular importer is not disclosing the goods, so the custom authorities have the right to take the possession of that particular asset. Okay, and followed by that the confiscation happens. As I told you, confiscation is nothing but it is taking away of the goods. Okay, that is by giving a punishment. So taking it away as a punishment. Next, what is confiscation of goods? Now, see, students, there are different scenarios under which confiscation of goods usually happen. Okay, so let us understand that first. So, any goods imported by sea or air which are unloaded or attempted to be unloaded at any place other than a custom port or a custom airport for unloading of such goods. So, students, this is a point. There are totally different situations here. They can be uh, I'll tell you, there are totally here, there are 5 situations under which why confiscation of goods happen. So what is the reasons? I will tell you all the reasons. Reason number one. Suppose they see, as I told you, the customs, the goods have to be unloaded only at the custom port or custom airport. But suppose some person is illegally, some importer is illegally unloading the goods at a particular, place which is not a custom port or airport, then his confiscation of goods will happen. So I am giving you the reasons why goods will be confiscated by the custom authorities. Number one, if any goods are imported by sea or air which are unloaded at a place which is other than custom port or airport, then his goods will be confiscated. Second, any goods imported by land or inland water through any route other than the route specified in a notification issued for import of such goods. See, students, whenever an importer is importing goods, he is given certain custom port, custom airport, custom station, or a land route where which is you know which is being specified by the custom authorities. Only there he can unload the goods. But suppose he's found some gupt route, he's found some secret route in which he's finding that he can unload the goods without payment of customs duty, and if he's being caught, then those goods will be confiscated by the custom authorities. So this is reason number 2. Reason number 3, any dutiable or prohibited goods brought into any bay, gulf, creek, or tidal river for the purpose of being landed at a place other than custom port, then his goods will be confiscated. Fourth is any goods which are imported or attempted to be imported or are brought within Indian customs water for the purpose of being imported, contrary to any prohibition imposed by or under this act or any law or time being enforced. So, suppose if he's getting any prohibited goods which he is importing, then also confiscation of goods will happen. Any dutiable or prohibited goods found concealed in any manner in any conveyance. So suppose if any importer is getting prohibited goods which has been concealed, hidden. Concealed means if the importer is hiding the goods in any particular conveyance, that conveyance is a means of transport. Okay. Or if suppose any dutiable goods are there, but he's hiding those goods because he doesn't want to pay customs duty on those goods. Okay. And if it is found in the notice of the custom proper officer, his goods can be confiscated, that can be taken away from the importer as a punishment. There are various different other reasons also, which I will just read it out or will tell you. Suppose if there is any dutiable goods or prohibited goods which are actually required to be mentioned in the import manifest. We saw in the import procedure that there is something called as import manifest, but if they are not mentioned, so those goods, if they are not mentioned in import manifest and they are there in the conveyance, then the goods will be liable for confiscation. Any other reason can be any dutiable or prohibited goods which are unloaded or attempt to be unloaded without the permission of the custom officer or without the supervision of the custom officer. Then also confiscation of goods can take place. Or any dutiable or prohibited goods which are removed or attempted to be removed from either the warehouse or maybe the customs port without the permission of the proper officer, or any dutiable or prohibited goods which are transited with or without transshipment. Suppose transshipment means further the goods will be moving somewhere. So if they are done without the notice of the custom officer, then confiscation of goods can take place. And suppose if the goods are prohibited, or either they are the dutiable goods and they are imported into India, okay, on which there has to be a clearance of the goods. See, first the officer has to give a clearance, green signal for the goods to enter. But without that only they have entered, then the goods are liable for confiscation. And there are different other reasons for which the goods can be liable for confiscation of goods by the custom authorities. Okay. Last, just one thing you'll have to remember is any notified goods in relation to the provisions of the Customs Act. Okay, for the purpose of carrying this particular customs process, if anything has been contravened, suppose by carrying out this customs procedure, import export procedure, if any notified goods that are notified by the custom authorities, okay, any particular procedure has been contravened, means going against the act, going against the rules that are framed, then if the importer or exporter goes against that, his goods are liable for confiscation. Confiscation. So this is the complete part on confiscation of goods. I have given you notes where I have specified several other reasons why confiscation of goods take place. So thank you so much, students. We are done for the session. And with this, we have completed module number 6.